On June 2, 2025, Malcolm Talley was arrested following an encounter with officers Jacob Ellis and Jacob Stearns of the Detroit Police Department. The initial arrest centered on a felony charge of felonious assault. Mr. Talley identified himself as a security guard with a valid concealed pistol license, which permits him to have a gun. Under compiled Michigan Law 750.82, felonious assault requires proof of criminal intent while explicitly lacking the intent to commit murder or to inflict great bodily harm. Following an initial dismissal of the case, the state refiled the matter under a charge of carrying a concealed weapon while under the influence. This charge was ultimately amended to a state civil infraction under MCL 28.425K, which penalizes a CPL holder for carrying a firearm with a bodily alcohol content at or above 0.02%. The prosecution contends that the officers observed what appeared to be a rifle with a weapon-mounted light sweep across their police vehicle, establishing probable cause to initiate contact, seize the weapon, and execute an arrest. However, the defense moved to suppress the evidence in violation of a defendant's constitutional rights. Defense counsel Dennis White asserts that the initial arrest for felonious assault was entirely unlawful, lacking the fundamental element of intent. The evidentiary hearing was held in the 36th District Court of Detroit, Michigan, before Judge Ramsey Heath. The state called their primary witness, Officer Stearns, to the stand to establish the structural timeline of the arrest. Following the direct examination by Assistant Prosecutor Tomika Horn, Mr. White began his cross-examination.
Thank you. Attorney Whitey.
At what point was my client under arrest?
I would say once the handcuffs were put on, he's not free to go, sir.
Okay, so he was arrested on the scene prior to be placed in the police van, correct?
Yes,
And what was he placed under arrest for?
FAPO.
Okay, felonious assault on a PO. Any other charges he was arrested for at that point?
At that time, no, sir.
Was he ever under arrest for brandishing a firearm?
No, sir.
Was he under arrest for being under the influence, being 0.08 or more blood alcohol content while being in possession of a firearm?
He did not go over 0.08, so no, sir.
Okay, so he wasn't under arrest for that, correct?
No, sir.
Okay.
He does an additional charge, sir.
Okay, fair enough. So fair to say that the only charge that he was placed under arrest for at that scene was for felonious assault on a police officer, correct?
My initial charge, yes, sir. But the additional charge would be carrying concealed while under the influence, yes, sir.
Okay, so that was the additional charge, correct? The carrying concealed under the influence?
Last week, yes, sir.
Okay, and are you stating that that was a misdemeanor, or are you stating that's just the civil infraction?
Well, again, with our system, it prints off as a misdemeanor, sir. So that's why we get a ratio ticket as a civil infraction, sir.
Okay. When he was placed in the van and then transported to the Detroit Detention Center, you also believed he was under arrest for having a bodily alcohol content of 0.08 or more while possessing a firearm?
No, sir. I said he was arrested for FAPO, an additional charge of carrying while concealed.
Okay, understand. So I'm crystal clear. The only charge you arrested him for was FA, or felonious assault on a police officer, correct?
Yes, sir.
Also known as, in Michigan, assault with a dangerous weapon under 750.82, correct?
No, sir.
Okay, fair enough. Okay. I believe he stated that you and your partner were in a scout car, correct?
You're in a work MPO, sir.
A van, okay. And you were the driver?
Yes, sir.
Okay. And you initiated a conversation with my client, is that correct?
Yes, sir.
Did you initiate with anybody else?
There was two others at the window.
Okay. Did my client tell you he had a CPL?
He never disclosed that, sir.
Oh, he never said he had a
No,
CPL?
someone else later on in the investigation did say he has a CPL.
Okay.
He actually refused to identify himself.
Yeah, okay. And you asked his identity after you arrested him, is that correct?
Once we detained him.
Okay. I believe he stated he's not answering any questions, is that correct?
I don't recall that, honestly.
Fair enough. Okay. And fair enough to say that, well, let me back up. Let's go through the incident. So after you and your partner get out of the car, you continue conversation with my client, is that correct?
Correct.
And then I believe you stated even two commanders showed up, Sergeant Honeycutt as well as two lieutenants. Is that yes?
Yes, sir.
Okay. And you discussed the incident with them, is that right?
Yes, sir.
And one of them actually said, that's FAPO, he's good to go, something of that nature, correct?
I believe so, sir.
Now, at that point, did my client retrieve the rifle out of a vehicle?
Yes, sir.
And he was directed by an officer to do that, is that correct?
I do not know that, no, sir.
Fair enough. Because you were talking to command officers, probably.
What's that, sir?
Because you were talking to command
Correct,
officers.
sir. I was
Okay, fair enough.
What's going on?
Okay, that makes sense. You had a Sergeant Robinson come to the scene, is that correct? Or Sergeant Robinson of the traffic unit came to the scene
With the PBT.
with the PBT, and that's a preliminary breath test, correct?
Correct, sir.
And Sergeant Robinson had asked my client to take a test, the PBT test, correct?
I wasn't there, sir. I can't testify.
Okay, fair enough, fair enough. Were you ever made, actually, fair enough. I'll leave, you weren't there, fair enough. Now my client is placed in handcuffs and then in the back of a transport van, correct?
Yes, sir.
And it's at that point that you were asking for his ID and his wallet, correct?
Either that or just before, sir.
Okay. But didn't you and the other officers have to let him out of the van to retrieve his wallet from his pocket?
He said he had it in his hand, sir.
In his hand, that's correct. He also had a knife on him, is that right?
No, he had the mace on.
Mace, that's right, mace. And that was on him when he was placed in that vehicle, correct?
Correct.
Now, you did the pat down to find a firearm on my client prior to that, correct?
Right.
You didn't find the mace?
I thought it was a lighter, sir.
Oh, I thought it was light, okay, fair enough. And the wallet you just left on him for that time?
Truthfully, I didn't feel the wallet.
Okay, fair enough. Is the Detroit Police Department policy to remove all weapons from a person prior to placing them in a transport van?
Yes, sir.
Also remove all lighters, is that correct?
Yes, sir.
And that just, it was busy, that wasn't done, correct? Okay. Actually, when you address the odor of intoxicants or alcohol, did you state to the charge not to rack things up, but he smells of alcohol?
Yes.
Okay. So that goes to support it was a secondary inquiry.
Well, yeah, my first part of our investigation was if there was a potential threat to make sure that threat was removed. Officer safety, number one. Okay. So.
Okay, fair enough. Didn't you state, well, actually, I'm gonna bring you back into when you're in the police van with your partner and you first pull up to speak to my client. During that discussion, didn't you tell him, we didn't think it was intentional in reference to pointing the firearm, correct?
True.
Is that yes?
Yes.
And just so I'm clear, on the property that was taken from my client, there was a bullet resistant vest, is that right?
Bulletproof vest he did have on.
Okay.
It was never removed at the location.
Okay, fair enough. But the Detroit Police Department took custody of that?
Yes.
And they took custody of the rifle, is that right?
I personally got the rifle, pistol, the radio, the
Okay.
CPL license.
Okay, so there was a pistol, a rifle, CPL license, and
His handheld radio.
his handheld radio. Okay, all right, fair enough.
Those
Just
were all
one
placed
moment.
on evidence.
I'm sorry.
I said that was all placed on evidence.
Okay, fair enough.
Mr. White challenged Officer Stern's search of the suspect by pointing to a failure to follow department safety protocols prior to transport. The officer admitted that he had mistaken a canister of mace for a lighter, leaving the weapon in the client's possession with no immediate seizure. Under Detroit Police Department policy, it is affirmed that all weapons and lighters must be thoroughly removed from a suspect before they are placed in a transport van. As said before in this episode, under Michigan Compiled Laws 750.82, felonious assault on a police officer requires a specific criminal intent to place an officer in reasonable fear of an immediate battery. Mr. White argued that if the firearm pointing was truly an assault, as the state alleged, the officer's contemporaneous admission to the client, stating that the police didn't think it was intentional, made the felony charge procedurally groundless. Mr. White then introduced evidence regarding the secondary inquiry into the odor of alcohol on the scene. Under MCL section 28.425K, carrying a concealed pistol under the influence is strictly evaluated by bodily alcohol content. A BAC of 0.02 to 0.07 constitutes a state civil infraction, while a threshold of 0.08 or higher elevates to a criminal misdemeanor. Here, because the client's preliminary breath test did not exceed a 0.08 blood alcohol level, the officer explained that the system required the additional charge of carrying a concealed weapon under the influence to be reissued as a civil infraction rather than a misdemeanor. The next officer was Officer Jacob Ellis. After the prosecutor finished her examination, Mr. White started his cross-examination.
Yes. Officer, I noticed at one point my client retrieves a rifle out of the backseat of the SUV. Is that correct?
Correct.
Did you direct him to do that?
I asked him to.
Okay. Is it common police protocol to tell a potential suspect who pointed a gun at a police officer to go ahead and retrieve that firearm and give it to me?
Not usually.
Okay. So you felt comfortable enough that he wasn't a threat, like he was going to try to shoot you or anything, correct?
I didn't want to escalate the situation.
Okay, fair enough. Fair enough. But if you're telling somebody to obtain a firearm, you do not believe that at that point, that he's a threat to you, correct?
I'm sure.
Okay. So normally if somebody, if there's a firearm, that say a Detroit police officer comes across in the middle of an incident, say a fight, a domestic, we'll say domestic, and they say there's a firearm over there in that dresser drawer, would you tell that person to get the firearm or would you go over and get it?
I would ask them.
You would ask them to put their hands on the firearm and then give it to you.
Your Honor, objection, this line of questioning is not exactly what's going on here. That's an example, speculation of what the officer would do in another type of situation.
Fair enough. Fair enough. I can move on. He answered. I can move on. I made my point, I think. Now, throughout your investigation, did you come to know that Mr. Talley was working security at one of those establishments?
Yes. Let's go with it. State that.
Okay, so he was actually working security that evening, from your understanding?
I'm not sure
Okay. But you did receive information that he was working security, correct?
that he was employed there.
Employed, okay, correct. Now I noticed that you registered, or you wrote down the serial number to this rifle. Did you subsequently run that through the law enforcement information network?
I did.
And did that rifle come back registered to my client?
I did.
Is it fair to say that my client was placed under arrest when he was placed in handcuffs?
I didn't place him in handcuffs.
I understand that. What I asked is, when he was placed in handcuffs, was he under arrest?
I would assume he'd been detained at the time.
Well, you're assuming that, but what I'm asking, you're the police officer.
Judge,
You're on
Your
the
Honor, he's asking an assumable question. This officer did not place him under handcuffs. He was on a separate detail at that time, so he would not have personal
Let me build
knowledge.
foundation. You know, I'll back up with
Thank you.
build up.
Okay.
Did you see my client placed in handcuffs?
No,
Okay. Were you the arresting officer, or was your partner technically?
my partner.
Now, when you asked my client for his date of birth, do you remember that testimony where the prosecutor asked you if that was lawful or not? Is that correct?
Correct.
You agree with me, though, that when you asked that question, my client was already under arrest, correct?
He was detained.
Okay. So he wasn't under arrest?
Like I said, I'm not sure at that time.
Okay. Who detained him then?
My partner.
Okay. So you'd rely on whatever your partner stated was the time of arrest would be the time of arrest.
Yes.
Okay, fair enough. And fair enough to say that when you asked for that date of birth, that my client was already in handcuffs.
Yes.
When this interaction started, you were the passenger in the police van, is that right?
Correct.
And you noticed the light and the firearm and then went to speak to my client, correct?
Correct.
And you stayed seated in the car?
I did.
And that interaction lasted at least 2 minutes, correct?
I'm not sure.
So for an officer, if you feel under threat, you want to get on your feet. You want to get out of the car, correct?
I would assume so.
Okay, and that's fine. In this case, though, you didn't feel that threat where you want to get out of the car to make sure you're on your feet when you first spoke to Mr. Taylor, right?
Correct.
We can rewind the video if we need to, but I'm just trying to speed it up. While you were sitting in the car, did you or your partner even say to my client, look, we don't think it was intentional what you did. You just act like an idiot, so to speak.
I don't recall.
Okay, you don't. Fair enough. As your partner was the arresting officer, you agree he decided the charges and what to move forward with. Is that correct?
Yes.
And of course, that was in consultation with a lieutenant and 2 sergeants, correct? Correct.
During Officer Ellis's cross-examination, Mr. White systematically undermined the element of a perceived threat. The defense emphasized that the officer remained seated in the van during the initial interaction, which directly contradicted standard law enforcement safety protocols for dealing with an active or lethal threat. Under the collective knowledge doctrine, the legality of a search or seizure is evaluated based on the pooled information of the entire active police team, rather than the isolated knowledge of a single officer. Here, Officer Ellis relied solely on his partner to execute the physical mechanics of the detention and establish the arrest timeline. Because his partner was the primary arresting officer who physically applied the handcuffs and ultimately formulated the charges after consulting with the supervisor, Officer Ellis's testimony highlights how the state's justification for the escalation relies entirely on the aggregated awareness of both officers working the scene. Under the doctrine de facto arrest, a person who is placed in handcuffs is heavily presumed to be under arrest. The defense utilizes this concept to argue that since the initial interaction was entirely non-threatening, the immediate placement of handcuffs bypassed a brief investigative detention and instead triggered an unlawful arrest executed without the necessary threshold probable cause. After that, Officer Ellis was released from the stand, and the court prepared to hear Mr. White's legal arguments.
Let's just look at what we heard in this hearing. We heard Mr. Talley, assuming everything's true that the prosecutors presented, all the witnesses are completely true. Let's take it all at their word, exactly at their word. We still win. First, basically they're saying Mr. Talley was pointing a firearm, he's being an idiot, basically. It was not good, it wasn't the safest thing to do. And I get that, I understand that. But what's very clear in this whole case is, was there probable cause to make an arrest? Let's look at things. First, the 2 officers are in a car. They pull up to these subjects. They don't get out of the car. They don't get on their feet. They sit there for, well, he doesn't even recall how long. They have a conversation on their tushies or on their butt, basically, in a car. If officers under threat that they're going to get shot at, they're getting on their feet. Now, of course, I'm not an expert in this by any means, but in my 15 years, you get on your feet. They did not feel threatened by Mr. Talley at that point. They were just trying to have a discussion. What made them upset was when my client gets argumentative. That makes them mad. And I get that. I watched the video. I was an officer. That teed me off too, right? I'm just trying to like make a point and move on and be done with it. That's what they were doing. And I'm not faulting them for that. But that doesn't make it a crime. When it becomes a crime is when they're upset and say, hey, look, they're not getting my point. I get where they're at with that. I do. Then they say, we're going to look at this a little bit further. Pull the van over, they get out. Then they start having a discussion with Mr. Talley. What does Officer Ellis do? He actually has my client retrieve the firearm from an SUV. So if an officer feels under threat, they're not going to say, hey, go put your hands on that firearm, sir, and then go ahead and hand it to me. They're going to retrieve that firearm themselves. I found it interesting, though, that the officer testified before the objection came out and I'd moved on. He said if it was a domestic situation and the gun was in a dresser drawer, he would probably ask them to go get it. Okay, fair enough. That's him. I understand that. You are not feeling threatened by any means. Okay, so that's the facts we have. Later on, there's a PBT. It was pulling some teeth for the officers to admit when my client was under arrest. They seemed to be very afraid and skittish around that issue. Both of them. When was he under arrest? We're trying to work around this because their case is weak. There is no probable cause. Now, let's look at that. The second one, Officer Ellis testified. He would rely on his partner's decision. He was the primary officer. He's the arresting officer. It's his decision. Fair enough. I understand that completely. But let's look at what we have. We have the first statement within a minute of this incident, and from that chair, the officer in charge admits, we didn't think it was intentional or anything. He says it, he states that he stated on that date, and he confirms it under oath, which I get. They didn't feel threatened. Totally understand that. But then I go over every possible charge they could have arrested him on. What charge did you arrest him on? Felonious assault against a police officer. Fair enough, felonious assault. So let's take that. We know that felonious assault under 750.82 requires a dangerous weapon and an assault. What is required for any assault in Michigan is common case in law, intent. The officer said on the video and confirmed under oath, we didn't think you intended to do it or anything. There goes their case, gone. It's over. I went through every other charge they tried to post hoc come up with. Well, he's intoxicated. Well, we didn't have the PBT at that point. Well, this and that. Nothing to show a PBT shows a point of weight, which is what's required to make intoxication while in possession of a firearm. It's to make that charge, you need 0.08 or more. They said, well, we think he's under the influence, which I get. They smelled alcohol, he comes back with something. And then later at the station, there's something. But no, there's no testimony, it's a 0.08. So let's take that charge. That's what the ticket was written for originally. That's gone now. We know that. That's gone. That was a defect. It doesn't even, the government had to dismiss that or amend, which we had no problem with, amend it to a civil infraction because they have to admit there's no probable cause on that. Let's go to the third one. What was mentioned today. Let's also look at what was mentioned in the people's response. It says, well, they had probable cause because it's brandishing a firearm. Okay, just because you have probable cause of one thing, you could have it for something else, which I get. But brandishing a firearm in Michigan, was it required? Intent. And actually, I'm just going to quote from the jury instruction. Brandishing a firearm, Michigan Criminal Jury Instruction 11.25a. Defendant is charged with the crime of brandishing a firearm. To prove this charge, the prosecutor must prove the following. First, defendant possessed a firearm or had control of a firearm. And of course, it defines a firearm as a weapon that will shoot out a projectile by explosive action, is designed to shoot out a projectile by explosive action, or can readily be converted to shoot out of a projectile by explosive action. Okay, cool enough, fair enough. Possessed, they got it. Cool, I'll give them that. Probable cause, they got it. Second, that while possessing or controlling the firearm, the defendant was in a public place. Give it to them. We're sitting here learned, right? Not a problem. That's out in public. Third, while possessing or controlling the firearm in a public place, the defendant deliberately pointed it, waved it about, or displayed it in a threatening manner. Okay, I don't think we can even say it's threatening given their testimony, but it's okay, Judge. We can actually give them that one too. Let's go to the last one though. Fourth, that when the defendant pointed, waved about, or displayed the firearm, he did so intending to cause another person or persons to be fearful. Intent is required. What is the statement from the grand arresting officer? We don't think there was intent or anything, and he confirmed it under oath. We went through every possible charge that they could have had for probable cause to make an arrest. I even nailed it down several different ways and said that was the only charge, was felonious assault, correct? Yes. There's no disputing that. There is no probable cause to arrest my client. Would there be cause potentially to write him a citation on the alcohol thing? Yes, but that's not for arrest. So I'm asking this court to rule that there was no probable cause to arrest my client. Therefore, anything that was taken fruits of that unlawful arrest, such as an intoxilizer 9000 at a station, would certainly be suppressed. That is governmental action. Now, of course, as an officer of the court, that's a civil infraction. So the rules get a little bit looser for civil infraction with respect to the exclusionary rule, but this is considered quasi-enforcement. This isn't code enforcement. So your grass is too long and I took a picture in the backyard when I trespassed. This is an arrest where he's deprived of his freedom, not only that night, until the next day. And so, Judge, we believe that any evidence of intoxilizer 9000 would be suppressed too. But first and foremost, there's no probable cause. And so we would ask that this court make that finding. I think it's not even close call in this situation. Thank you, Judge.
Thank you. I will allow rebuttal if you have any. Do you have any other statement you wish to make to the court? Ms. Warren?
And in closing for the people, I believe there is probable cause here. He was suspected of being under the influence of alcohol during this investigation. He was in possession of a firearm, and I believe that is the probable cause necessary to prove this ticket on the civil infraction that he was under the influence. He smelled of alcohol. He did test his alcohol at PBT at that time for 0.06, I believe, and at the DDC. Now, what's going on at the DDC is not necessary at this hearing today, but for purposes of this civil infraction, he was above a 0.02, Your Honor, under the influence. And not only did he have the rifle that he allegedly pointed at the officers, he also had another gun or firearm that he had failed to disclose to the officers altogether until a pat down. This community deserves better, Your Honor.
Anything further, Mr. White?
It does deserve better. It deserves a better investigation and deserves better enforcement. I don't fault these officers one bit. I did that job. I don't fault these guys. They're trying to be safe. I get it. They're under tough circumstances, but it still doesn't rise to the level of probable cause in the situation. It just isn't there. If we want to talk about the reason for an arrest could be under the influence, there's nothing in this record to say there's a 0.08 on a PBT or otherwise. And even later, we're not even at that point. So there just isn't probable cause here. I'm not attributing ill will towards these officers and that they were trying to do anything evil by any means. I think they were trying to educate Mr. Talley. That didn't go so well. And so they made their point another way. Fault them.
Right.
But that doesn't rise to the level of probable cause.
Right. Thank you.
Mr. White reinforced that all the alleged evidence should be suppressed. Under the exclusionary rule, evidence is suppressed when it is obtained as a direct result of an unlawful, unconstitutional search or seizure, such as an arrest executed without probable cause. This argument relies on the fruit of the poisonous tree doctrine, a legal principle establishing that if the primary source of the evidence is tainted by illegal police conduct, any secondary evidence derived from it is automatically inadmissible. Because the initial arrest lacked legal justification, Mr. White informed that the subsequent evidence must be excluded from the hearing. Under Michigan Criminal Jury Instruction 11.25a, person who is prosecuted for brandishing a firearm cannot be convicted unless the prosecution proves specific statutory elements, such as possessed or controlled a firearm, was located in a public place, and deliberately pointed, waved, or displayed the weapon intending to cause another person to be fearful. Because Officer Stearns testified that law enforcement did not believe Mr. Talley's handling of the weapon was intentional or meant to threaten, the specific intent required by the jury instruction is completely absent, invalidating the charge as a basis for probable cause.
There's a reason that we have a probable cause standard. And that standard is that it must be based upon a reasonable suspicion that a particular crime has occurred or is about to occur. Here, it's obvious that the particular crime that was being alleged was the use of the firearm, a felonious assault, the use of a firearm in the felonious assault of a police officer. I will say, I find the officers to be credible in this case. As I watched, although it's not part of the record, both attorneys and the court have watched Officer Stearns' body cam video, as well as now Officer Ellis's. What occurred to me in watching that video was that given the number of officers that converged on the scene, it became almost like a game of telephone, where the first person to encounter says one thing and that starts to balloon out to something else. What seemed to be communicated by Officer Stearns, who was one of the first on the scene, certainly, it's not as clear to me from Officer Ellis, but that the firearm was being handled in some way. And in the handling of that firearm, sounds like from the testimony today that the light was initially pointed at feet, came up and around as it was being placed back in the vehicle where Mr. Talley had to retrieve it from. That's borne out in the officers' statements that they did not believe the aiming of the firearm at them to be intentional. However, on the scene, things started to change because now the allegation is going through various officers and it starts to kind of take on a life of its own. And Mr. Talley then ends up in handcuffs, arrested on suspicion of felonious assault on a police officer, pointing a gun at them, even though both of the officers first on the scene said that they did not believe there to be an intentional aiming. But he ends up in handcuffs, not free to go, as Officer Stearns testified, in a van, and what this court finds to have been under arrest. Officer Stearns said that he would have considered it to be under arrest because he was not free to go. And Officer Ellis said, well, whatever Officer Stearns says. If he says that's when it occurred, that's when it occurred. So clearly here, the arrest was for the felonious assault on a police officer. I know that there were some other cases running along with this. The court has had trouble, quite frankly, making sense of them because the register of actions contain all kinds of different weird dates about the date of offense. But what we did pull was that it would appear, although it contains a different date of offense, I don't know why, that there was initially a charge for fingerprinting refusal as to Mr. Talley. Don't know if that was the same case. Okay. But that one was dismissed for compliance. I then had another case where Mr. Talley was charged with, looks like an assault and battery, found not guilty by a jury. Again, I can't make sense of the offense date in that file. And then I have another case from 2025 where I can't even tell exactly what the disposition is here. The latest thing I can see is an October 29th entry there of 2025, and then nothing further, no final disposition. I'm sorry. I am looking at an October 27th date in 2025 where there's an order of dismissal. So, you know, I don't know if any of those others are riding along with this one, given some of the allegations that were made. But given what I think is the officer's, quite frankly, very credible testimony, I do not believe that either of the officers perceived a threat to them at this time. An intentional threat. Again, borne out by the statements, borne out by asking Mr. Talley to retrieve his own firearm and hand it to the police, you know, and, you know, perhaps this is what would happen under the same circumstances. I don't know. You know, as a layperson, you know, familiar with the law at least, but not an officer, certainly I'm not going to ask a person who I feel is a threat to me to go and grab a firearm. I mean, that's just a logic. So at this time, I do find that there was no probable cause for the arrest for felonious assault on a police officer.
Judge Heath determined that there was no probable cause for the arrest. According to the judge, the incident on the scene rapidly devolved into a game of telephone due to the sheer number of secondary officers who converged on the location. Officer Stearns also confirmed that Mr. Talley was not free to go, testifying that the defendant had been placed in handcuffs and secured inside a police van. The court noted that these severe restrictions on the defendant's movement established by the officers that Mr. Talley was fully under arrest for felonious assault on a police officer. Because the officers openly conceded that the sweeping of the firearm was entirely accidental and was not perceived as an intentional threat, the judge ruled that the essential element of criminal intent was absent. Consequently, following the court's finding of a total absence of probable cause to justify the initial felony arrest, the criminal charges were rendered untenable, shifting the remaining legal determination exclusively to the civil infraction surrounding the firearm possession. The last officer called to the stand was Captain Heather Cameron, the commanding officer of the Detroit Police Department's Property Management Unit.
Mr. Talley. Captain Cameron, where are you currently employed?
Detroit Police Department.
And how long have you been with the Detroit Police?
25 years.
And at this time, are you considered like the custodian of forfeited firearms?
I'm the commanding officer of the property unit, yes.
Okay, and what does that entail that you do?
It's one of several units that I am in command of. There's also a lieutenant, 2 sergeants over property.
And in this matter, were you able to, take possession from evidence, at the Detroit Police Department, Mr. Talley's property?
Yes, ma'am.
Do you recall what items are included in the evidence? And if you need something for refreshment, I do have that.
There's a long rifle, 2 magazines, a CPL permit, a handgun. Those are the items on evidence.
And was there any other additional items that weren't on evidence that you have in your possession today?
Bulletproof vest.
You heard the court's order.
I did.
And is there a process that Mr. Talley has to take, including in addition to the court order? May I present the court order to you?
Yes, ma'am.
Okay. May I approach, Your Honor? The people are presenting a court order dated February 5th, 2026, that has been held in abeyance as a reason until today's hearing. And at this time, I believe the order is going to be enforced by the court.
Correct. And for clarification, there was a period of time when the order was not held in abeyance. However, given the city's request to respond to the motion, I then pulled it back. I believe it was February the 13th, and held it in abeyance until we could resolve the matter.
Thank you, Your Honor.
Mhm.
And Captain Cameron, for the record, have you had an opportunity to review the order that we've been discussing?
Yes.
And as a result of that, is it your understanding that the city has to comply with the order?
Yes, ma'am.
And is there a process that needs to be taken outside of the written order enforced by the court today for Mr. Talley to retrieve his items?
The court order needs to be presented to the precinct of occurrence, which in this case would be the 3rd precinct. The supervisor will then review the order, complete a task in our tracker system, have it approved by the captain or commander of the command, which is 3rd precinct. Then with that information, a task number will be provided to the offender, the owner, to the owner, and he would take that information to the property unit at 1301 3rd Street, provide the task number to the property officers, who would then return the property to him or her.
Okay. And at this time, to begin that process, will he present in person for that to the 3rd precinct?
Yes, ma'am.
All right, thank you, Captain Cameron. I don't have any further questions at this time. I'm not sure if the court does or.
I want to make sure for process, when the order is presented, because we'll get it today, we want to get it presented as soon as possible. When we present that to, I believe he stated the commanding officer at the 3rd precinct, and then has to go through some channels, how long does that take?
Could take 24 hours.
Okay, we're talking in days, not months, right?
Correct,
Okay.
but the property room is only open Monday through Friday, 7 a.m. to 1 p.m.
Okay, and then he would have to go to 3rd Street to the headquarters to that with the task number to get retrieved.
Correct.
Okay, I appreciate that. Thank you, Captain.
Thank you.
Okay, thank you, Captain. No further questions.
Can I ask just one question with this order?
Mhm.
In normal cases, when we get court orders, live ammunition is never returned. Is that fact with this case also, or no?
No, I mean, I don't have any information that there's any suspicion that this gun has been used in other crimes. I don't have any suspicion that the ammunition was illegally obtained or illegally possessed. There is no conviction standing that would prevent the return of Mr. Talley's property.
Okay, thank you. Just wanted to be clear.
Appreciate
Okay,
that.
thank you. Thank you. Yeah.
Anything further?
I think
all the issues are resolved one way or another.
All right, thank you. It sounds like we have established that the department does have all of the property in their possession. Mr. Talley has a roadmap to follow to get that property back. Sounds like it shouldn't take very long. And then if you start it tomorrow, you might have it within, I would expect that you would have it within a week. At most, given. Now, the court's done a little bit of research on this too, and it seems that the only thing that should prevent the return of the property is the discovery that Mr. Talley is for some other reason prohibited from having a firearm. I don't have anything to indicate that.
Judge Heath confirmed that Mr. Talley could have his belongings retrieved. Captain Cameron confirmed the items in evidence according to the department's property records, listing a long rifle, a handgun, 2 magazines, and a CPL permit. And after seeing that there was no standing conviction or legal prohibition preventing Mr. Talley from possessing firearms, Judge Heath ruled that the original order for the return of property stands and must be fully enforced, clarifying that the city has no lawful basis to withhold any of his belongings, including live ammunition. This evidentiary hearing underscores the critical importance of constitutional compliance in law enforcement actions and highlights how strictly courts must evaluate the statutory requirements of an alleged offense. Mr. White's cross-examination of the arresting officers illustrates why courts must evaluate the specific context of an interaction rather than relying on post-incident justifications. To execute a lawful custodial arrest, law enforcement must possess probable cause that a specific crime has been committed. Because neither officer perceived an immediate threat or believed that Mr. Talley acted with criminal intent, the foundational elements required to sustain a felonious assault charge were completely absent. Consequently, because the initial arrest lacked a valid legal foundation, the state maintained no lawful basis to seize or withhold the defendant's property under the umbrella of a parallel civil investigation. Ultimately, the court determined that the police lacked probable cause, suppressed the resulting evidence under the exclusionary rule, and ordered the state to immediately return all of Mr. Talley's seized possessions. Comment below if there is a case that you would like us to cover. Thank you for watching, and don't forget to subscribe to see more case analysis.